Welcome to Close to Home with Nicole Sullivan.
Hello and welcome to Close to Home with attorney Nicole Sullivan. I am your host, Kevin Rosenquist, and in today's episode, we're exploring the crucial role family dynamics play in estate planning. Nicole will explain why it's essential to have a deep understanding of a family's unique situation when creating and maintaining their estate plan. We'll talk about how she strives to grow with families over time, providing the support they need as their lives evolve. Nicole, so great to see you again. Thanks for being here.
Good to see you, Kevin.
So why is it important for you, the estate planning attorney, to have a real deep understanding of a family's dynamics and intricacies when it comes to creating and maintaining an estate plan?
You know, a lot of people come and sit down with me when we start talking estate planning, and they think their situation is so much different than everyone else's. And they think that there are things that they don't need to tell me that are personal to them, or situations that they may even be a little unhappy with explaining their situation. They may feel ashamed in some way, but really, I'm here to help you. So I have to know everything about your family dynamics and your life situation, because I need to figure out how to best protect you when it comes to once you've passed away. And
Right.
In order to best protect you is I have to know everything. I'm your attorney. I'm your friend. I know
you're not there to
you,
judge. You're not there to judge people. Yeah.
Absolutely not. I'm not there to judge, because again, I have probably heard a situation that is very similar to yours. And again, most of my clients, yes, their situations are all different, but they're not so unique that I haven't heard a similar situation before, because I have to see how these different situations play out. And in being in practice for 8 years, I've spoken to a lot of people. I have seen a lot of different situations, and it doesn't surprise me. I guess I should say that. No situation surprises me, or if it does, good. I can learn with you and to make sure that I can do what's best for you and your family. So, for example, a lot of people, surprisingly to many out there, but not surprising to me, have a situation where they may have 4 children, but there may be one that has taken a path that they don't necessarily agree with. And it could be they're not good with money. They could be on drugs. They could be in prison, whatever the situation may be. And the testator, or the person creating the will, has worked really hard for their money and what they've created in the estate that they've created over their lifetime. So they want to protect that. While they love their child, they know that their child won't maybe even benefit from the money they may receive, because they could potentially go down an even deeper, darker path with whatever inheritance they may receive. So for that reason, they want to leave that child out. I have situations that arise where people will just tell me they have 3 children, even though they have 4, because they don't want to go through that. They don't want to talk about that. They don't want to have it notated in their will that they're leaving this child out. However, we have to do that. We have to address every child that you've had, even if a child has predeceased you. Those children must be listed in your will. And the reason for that, and why we want to make sure we do that, is because if we don't list a child in your will that you may have had before and they have passed away, or a child that you don't necessarily agree with their path or think that they need to inherit from you, we have to at least list those persons in your will, acknowledge and otherwise omit them. Or in the situation of a child that's predeceased you, we have to at least acknowledge that child and say, this child has predeceased me. These are my 3 living, so these are the 3 that will inherit. We have to address that. The reason for that is, let's say that 4th child that's taken the wrong path, the will is probated by one of the 3 children that you have. They're named as the executor, and they come forward and say, wait, they forgot about me. I'm what's called a predetermined heir. I think that's how you say it. Best I can say it in my Mississippi accent. But in other terms, it means a child that's been left out or otherwise forgotten. We have to list everybody. And that's a situation that someone could come and contest the will that you've created. You're trying to make sure that person isn't involved, but really you've opened the door to allow them to become involved. So you have to at least name all of your heirs and say, while I love Kevin and I acknowledge him as being my son, but for reasons that are known between he and I choose to otherwise omit Kevin from inheriting under this will.
What?
Sorry, Kevin, you're being left out. You're just the name I have in front of me.
I had it coming. Let's be honest.
It happens all the time.
Yeah.
And again, we have to address all of those children, because you don't want the situation to be that they come up and say that they've been forgotten, because guess what? If they're not listed, then they're entitled to a child share, meaning they will get a fourth of the estate. So you need to make sure and have those children listed, even though your intention is not to include them. So that just kind of goes back to the intricacies of your situation have to be explained to me in order for me to best protect you and best protect your other children or your other beneficiaries. It doesn't have to be your children. It could be your church. It could be the Humane Society, whatever it may be. In order to best protect you and the assets that you've accumulated over your lifetime, I need to know everything. Bring all the monsters and little creepy crawlies out of the closet. I got to hear them all. And the reason for that is it's best for you. As much as it may be difficult to talk about, I'm trying to help you and I'm not going to judge, kind of like you mentioned. There's no judgment here. There's only advice and legal guidance, and that's what I'm here to do.
It's like when you go to the doctor and they say, so how many drinks do you have per week? And you're like,
Everyone's answer is 2, right?
You downplay that. But you probably should be honest, right? And it's your doctor we're talking about here. You don't need to lie to your attorney. You don't need to lie to your doctor. Yeah.
Right. Exactly.
So what different aspects do you look at with the family when you're in an estate planning session?
So again, most important is who are your heirs. We go through that first thing. I got to know, your legal name, your marital status. That's also super important. Even if you are separated and plan to be divorced, we need to at least state in the will that you are still married, and then say that you're separated, and have in the will that, you're only giving your spouse this certain amount of whatever it is, because here in Mississippi, you cannot disinherit a spouse, interestingly enough. So you can disinherit a child, but you cannot disinherit a spouse. So something that we need to talk about is your marital status, even if it may be a touchy subject. We need to talk about your assets. And I don't necessarily mean every single bank account that you have, every retirement account, every CD that you hold, life insurance policy. I don't have to know all that, because again, my suggestion to you is going to be to make beneficiaries or list beneficiaries on those accounts and list contingent beneficiaries so that those pass outside of probate. But I do want to at least talk to you about those assets so that I can give you that advice to say, hey, you're trying to avoid probate. Here's how. So we talk through those various assets. The other thing that I like to address are the real properties that may be owned by the testator. Real property is your house, the land that it sits on, the random lots you may own, any property that you may have inherited in a different state. All of those things, we need to talk about all your real property and how we're going to address avoiding probate with those properties. I have so many situations where people remember and consider their biggest asset, which is typically their home. But if they've purchased a small lot in a subdivision many years ago, a lot of times they don't think to tell me those things. So if they forget those items, then we're going to have to probate their estate because we have not titled those items appropriately in order to avoid probate. Same thing if you would have a trust. If you forgot those items and they're not titled into the name of your trust, then that pour over will would come into play. So no matter what, that's why we have
a house that you own. I don't like, what kind of money do you have to forget about a house you own?
Not necessarily houses. People forget lots. Let's say this comes up a lot. Here in Mississippi, you can purchase properties for unpaid taxes. So you purchase the tax interest in them. So you've acquired title to those lots via a tax sale.
Okay.
People don't think about that. They paid $300 10 years ago. They paid $80 a year on these taxes for very small lots in very small parts of town that aren't worth a whole lot. And it comes up when we talk about estate planning and I say, okay, do you own any other properties? It's not necessarily, rental properties or properties with physical buildings on them. It's going to be a random lot. And people get upset when we have to probate for a lot that's not worth the attorney's fees involved.
Right.
I was just going to say, the only way,
yeah, that's a bummer.
So that's why I have to go through these things. Are there any other properties? Do you have any lot? That seems like a silly question to have to very specifically ask people, but those are things that are out of sight, out of mind. They don't have to go mow the grass on them because they're just a lot with a bunch of trees on them. So it's just little things that I like to go through every detail of everyone's life, every asset. I don't really have to go through creditors and again, specific bank accounts or anything like that, but I just like to know a general family dynamic. Who's involved in your family? Do you have any children involved? Are we going to have to create what's called a testamentary trust? And by children, I mean a minor. And interestingly, I think this is something not most people know, but here in Mississippi, you are a minor until age 21, not 18. Mm-hmm. So we have to provide for minor children, even if they're away at college. I have to ask you, how old are your children? If they're under 21, we need to create this testamentary trust that provides for who the guardian is, who the trustee will be that's going to be in charge of the money. This is, of course, in case anything happens before that minor child turns 21. At what age will the child inherit the money? Do they want to do it on a monthly basis where they basically receive an allowance, or is it a lump sum? Do they have to graduate college in order to get the money? There's a lot of things that we talk through and things that people don't really think about until I say, well, wait a minute, are you sure at age 21 they can handle a $250,000 life insurance policy that they're going to inherit? Are they going to blow it? You know better than me, but I just want to put that out there. At age 21, I wouldn't have been able to do that. And I consider myself relatively responsible.
Yeah, I would have bought so much pointless stuff, but I would have had a lot of fun. I'll say that.
Right. We would have had a lot of fun. I went to LSU. I'd probably bought a round of drinks for the whole bar, but
probably. Yeah. I guess I should clarify. I feel bad saying I'd have a lot of fun after like a family member died, but
right.
It's still.
Hey, everyone deals with grief differently.
That's true. Thank you. Appreciate that.
That'll be the way that you and I deal with it.
Yeah, right.
But hopefully that answered your question. There are a lot of things we talk about, a lot of intricacies, but when it comes to estate planning, I just need to know everything about your life that you didn't even think was relevant.
When does someone need to come in to update or adjust their estate planning documents? Or what life changes do you recommend people revisit their policy or their plan?
I think major life changes. For the most part, I try to create an estate plan that will stick with you for a long time for different situations. Again, I want you to provide for an alternate executor. If we have to create a testamentary trust for your minor children, I make sure to have alternate guardians, alternate trustees. I want to make sure that your will can continue with you through life's ups and downs, and it ebbs and flows with you. But there are certain situations where we'll need to change that. Most important would be a marital change. So let's say you were married at the time of creating your will and you're now divorced. We need to make sure to address that. We don't always need to address it if you become a widow, because most of the time it's accounted for in your will. That let's say you wanted your spouse to be your executor, but then you wanted your son Kevin to be the alternate executor. So when the first of a married couple passes away, it's not typically necessary that we have to then go and adjust the will. But I would like to at least review it with you to make sure everything is as you would like it, or we can even amend it to add another alternate in the case of, let's say, Kevin isn't available. Let's say you've passed away, or let's say that you've been stationed overseas. Something happens and you can't act as the alternate. We then add a secondary alternate. So we can do that via what's called a codicil, which is an amendment to the will. And that's relatively simple to do. So think major life changes. So your relationship or marital status has changed. If one of your children has passed away, if you want to disinherit a child, their situation has changed and they have become involved in something that you don't feel comfortable with, then we can change those things. Let's say your wishes have changed in some way. So let's say that originally you wanted the remainder of your assets, once both you and your husband have passed away, to be split equally between those 4 children that we talked about earlier. If you decide instead of it being equally, you want them to receive different percentages, again, your wishes can change at any time. And if they do, come see me. If there's a specific bequest you want to add, and a specific bequest is a specific gift. So say you purchase a really cool antique truck that you specifically want to go to your grandson Walker, then we would need to add that to your will. So just little situations we can do what's called a codicil or an amendment to your will, but there may be situations that we need to do a totally new will. But for the most part, just think big life scenarios, big life changes. That's when you need to come see me. But I'm happy to review anything at any time just to make sure what you want is taken care of in your will.
You can sense like that you appreciate the long-term relationship that you have with a family as far as making sure they have a successful estate plan, making sure they're taken care of. What does that long-term relationship mean to you and the people at your firm?
The long-term relationship with any and all of our clients is very special to us. So we may not see a client for 2 to 3 years, but a client is always family to us. I explain when I meet with new clients and even existing clients that I want to be your friend. I try to make sure that it's not a stuffy place for the clients to come and speak with me. I want them to feel comfortable, and I want them to feel like I'm a part of their family because they have become a part of mine. And by mine, I mean Sullivan Law Firm. All of my employees, my associate, all of us feel the same way. We know that estate planning and estate administration and probate is a difficult process and something that a lot of people consider taboo, and they don't want to talk about it, and they put it off and they put it off. But most of the time when they come into our office, they're like, man, this is so much simpler. You made me feel so comfortable. I feel like I can talk to you about anything. I'm like, great, because I want you to come back to me. I want you to feel like you can ask me any question, and that I want that to continue throughout the longevity of my firm. I've been an attorney for 8 years, but I've had Sullivan Law Firm for 3.5 now. And I feel like that's the theme. I want you to feel like a friend of mine because you've become my family. And so the long-term relationship with us, no matter what, I want you to be able to come to me and ask me any question that you have, whether you think it's stupid or not. It's not, because somebody else for sure has asked, and there are no stupid questions. None.
Well, you can sense your passion. So I think that's really cool that you have that outlook on the long-term relationships with your clients.
Yeah, communication is key here. I know I've talked about that before, but that's really what we try to, or what we pride ourselves on, is communication and keeping the client first. So we're very client-centered, communication-based. If you look at our website, that's a lot of the theme of that. Again, it's all about feeling comfortable. We've tried to do things a little different here than a lot of traditional law firms. And by different, I mean, we're a little more relaxed. We're a little more approachable. And I want to continue that because I think that's what the world is moving toward. We're obviously moving towards digital, but we're also moving towards, we don't need to wear stuffy suits for you to respect our opinion and our advice.
Right.
I think that it's more beneficial to you to feel like we're equals, because we are. And so I really feel like that's important when it comes to law firm practice and our firm in general. That's what we pride ourselves on.
Well, I think that's awesome. And thank you for tuning in to Close to Home with Nicole Sullivan. To connect with Nicole and the team, visit sullivanlawfirmplc.com. And please like and subscribe to our channel and leave us a review. Nicole, great chatting with you again. Thanks so much for joining me.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.